Petitioner issued a ruling which the petitioners certainly didn't like. On the other hand, I think the basis for the doctrine of exhaustion of administrative remedies has always been twofold. One is the development of expertise within the agency, and secondly, an orderly process of government. I think that to encourage these sorts of collateral piecemeal appeals really undercuts the orderly processes of the professional conduct proceedings. I think it delays the proceedings, and I think it certainly is not only bad for society, but I think it's bad public policy. So that is essentially our first point.
I thought I could save you a few minutes by making it for you.
All right. Well, thank you, Your Honor. I'm sorry. I hope I didn't go into it at too much length, but it is certainly a central point for us in this case.
Is a response to that, to prolong this a bit, however, that there may be some issues which are so fundamental, even in the administrative process, like a commissioner or the head of an administrative agency interfering with the independent quasi-adjudicative authority of an individual who wears a couple of hats, maybe, in the sense of they're fulfilling a responsibility as a subordinate, but it's supposed to be independent. If that issue cuts so fundamentally, is there no recourse other than the ultimate review that you would hold us to?
Well, I think the answer to that has to be yes, that there is no recourse. Because even if you review this court's prohibition decisions, which this has been analogized to some extent, in those cases, the court virtually accepts the principle that there's a fundamental constitutional or abuse of power claim. And then it goes further than that. It says, not only do we have to have that issue present, but we have to have other factors. There has to be no adequate remedy at law. We look at the discretion of the judge, and we look at various other factors. And in the prohibition cases, of course, one of the underlying issues is that if there's a determination on that issue, it will essentially make the proceeding inapplicable. We use the word moot. I think the key issue has to be here that even assuming that this is such a fundamental issue, and I don't think it is, but even assuming that it were, there's an essential ingredient to the orderly administrative processes where there's no irreparable harm, where it's not futile, and where the issue can be preserved. I think the decision has to cut in favor of having that process exhausted. If I can turn to the second point, assuming I'm incorrect on the exhaustion argument and this court were to reach the merits in the Doe case, the second issue presented is whether or not the commissioners had the power to do what he did in this case, which is essentially to reverse the administrative officer on an evidentiary or what we essentially feel was a legal ruling. The answer to that question, I think, has to be absolutely yes for at least three reasons. In the first place, if you look at the course of the administrative proceedings, the committee was at an impasse. The committee could not go further because the administrative officer had ruled that the complainants had to testify. The Office of Professional Medical Conduct was unwilling to permit the complainants to testify because the legislature had said these reports are absolutely privileged and confidential. So the committee did what I think was appropriate under the circumstances. It submitted a report to the commissioner, and it asked him to take whatever legal steps are appropriate in this matter. The commissioner responded to the impasse. He acted within the scope of his authority, which is to enforce and interpret the public health law, and he interpreted accordingly. This wasn't a narrow procedural issue. This wasn't a situation where the commissioner stepped into the proceedings. Basically, he was asked by the committee to act, and he acted. And there was a need for him to act so that the hearing could be continued. The second reason why we feel what the commissioner did was appropriate was because we think it's within his powers to do that. The commissioner has broad powers under the public health law to enforce and interpret the statutes. He has broad powers under Section 230, the medical misconduct provisions. consistent with those powers, it's entirely reasonable for the commissioner to be asked to interpret what the statute means. What did the legislature intend when it said that these reports are confidential? Did it mean always confidential, or did it mean there can be an exception when a witness testifies at a hearing?
Mr. Zwickel, where within Section 230 specifically do you find the power?
Your Honor, the answer to that question is twofold. The commissioner's powers are broad in the public health law in general in 206. Within 230 itself, there is no explicit provision which addresses this particular section, this particular situation. What powers the commissioner does have, he has within the course of a completed proceeding where the committee makes findings, conclusions, and recommendations, and they bring those recommendations up to him and he reviews it. One of the arguments that we make, and we think there's very good support for it in strong authority, is that if the commissioner could have, at the conclusion of the hearing, reviewed what the committee found and determined, or what the administrative officer had done, it's implicit in those powers that the commissioner could do it beforehand in the very limited situation that you have here. So the answer is, it's not explicit in 230. It's implicit.
No, go ahead.
I was just going to say it's implicit in his overall and general powers. It's also implicit in some of the fundamental powers that the commissioner has. He has powers to designate the AO. He has powers over the committee members. He has powers over the course of proceedings. Judge Hanks.
One word that you used gave me a slight problem. That's the word reverse. Now, is the determination, the ultimate determination, which imposes the punishment or whatever, the determination of the commissioner, or is it the determination of the administrative officer, which is then modified or affirmed or reversed by the commissioner? Where is the administrative determination which is ultimately reviewed by a court?
Well, Your Honor, I think the answer to that is to look at the process. The administrative officer is charged under the statute to make determinations, including legal ones. That determination, as far as we're concerned, is a determination in the first instance. The statute doesn't use the word final authority. It says designate an AO to rule on certain matters. And if you look at the legislative history of when that provision came in, it was very clear that the legislature contemplated the administrative officer assisting the committee, not taking away powers from the commissioner. The answer to the second part of that answer is that after the administrative officer rules, or after what should have happened, the committee includes those rulings in its findings, conclusions, and recommendation, the Commissioner of Health is charged with reviewing that. He then makes his own recommendation. He does not have final authority in this process. His recommendation is then transmitted to the Board of Regents, which then issues the ultimate determination. It is conceivable in this situation that after the committee concludes its work in this matter, and the matter goes back up to the commissioner, and it goes up to the Board of Regents, the Board of Regents could disagree with the commissioner. One doesn't assume they would, because here you have Dr. Axelrod interpreting his own statute, but certainly the scheme permits that to take place. What the commissioner did here, of course, is he didn't send it up to the Board of Regents, and I think that was correct. The hearing wasn't concluded. It was really an interim situation. It was an exceptional situation. And he was basically asked to deal with an impasse and interpret his own statute. That seems to us and to the Department of Health to be an entirely reasonable and rational thing for him to have done.
Has he been sued here?
Excuse me?
Has service been affected on Dr. Axelrod?
There's not been an issue as to service, Your Honor.
You're not going
No.
Mr. Zwickel, do you claim then that the commissioner has ongoing de novo review? And, I mean, do I take it from your argument that it's not just a question of de novo review when the final matter comes to him, whatever final means, but there's a day-to-day review as if he could get daily copy and, keep going up and down the ladder?
Your Honor, that issue, of course, isn't presented by this case. It would seem that if the commissioner were to step into a hearing on a day-to-day basis and review procedural rulings that came up, or even evidentiary rulings, that probably was not what was contemplated by the legislature. What was contemplated by the legislature, specifically in the statute, was a role for the commissioner after the hearing is concluded. However, we do believe that the commissioner has broad powers in this area. He has broad powers to interpret the public health law. And in the exceptional situation, which this is, where there was clearly an impasse and his guidance was sought and he was asked to enforce and interpret the public health law, that was an appropriate matter. I don't think those other issues are presented, but clearly what the commissioner is as concerned about as anyone else is the orderly processes of this process. And I don't think the commissioner would take the position that he can certainly reach out and walk into every single ongoing hearing. He doesn't want to do that, and it's not
When the
appropriate.
commissioner acted here, this whole proceeding was at a standstill, wasn't it?
That's absolutely correct. In fact,
And it was going to go no further until he acted.
and if he hadn't acted, what would have happened is that the committee could not have ruled. In fact, the committee admitted that. The petitioner was not going to put on any further witnesses. And what you do have here, and I'll be very quick about it, is the third issue, which is the privilege. What the legislature said in 230.11a is that all reports of information are privileged, and they may not be used in administrative or judicial proceedings. The reason for that privilege was to encourage people and doctors to come forward. It is, as this court held in Grattan, with respect to a different but similar privilege, it is a societal privilege which cannot be waived by the
So you're
individual.
using up your rebuttal time now.
All right, Your Honor. I'd like to have a minute and a half if I can. Thank you.
Mr. Halpern? Mr. Halpern, you heard from my question and
Yes.
the question of others, my particular concern.
Yes, we deal with it.
Unlike the next case, which deals with subject matter jurisdiction, here we're talking in terms of an evidentiary ruling.
We're
Should
dealing,
our
no,
court
we're
be
not.
involved at this stage in
No,
these
you're
cases?
you're out of focus on it. What we're dealing with here is the authority of the Commissioner of Health to go ahead and reverse a ruling and to do something which he has no power. Certainly, if I brought this case to you, that it was the Commissioner of Motor Vehicles who overruled this body, and we argued that it was beyond the scope of his power to take some position in overruling an administrative law judge in a medical disciplinary hearing, I don't think I would have any problems. But if you read the statute here, the Commissioner of Health has absolutely no role in the decision-making process other than to make a recommendation to the Board of Regents. And the legislature was quite careful in circumscribing the powers of the commissioner. The only function the commissioner has in this is that with the consent of the governor, he appoints people to the Board of Professional Medical Conduct. That's on the lay people. He designates an administrative law judge, much the way the governor would appoint from a panel the judges of this court, and he acts as the prosecutor at that point. He is not the fact finder, that is left to the panel itself, and he is not the person who makes the law decisions governing the case. That is left by the legislature to the administrative law judge. The statute's quite clear after that fact.
I thought you see that you're quite right. My focus probably was wrong because I had taken it that this was the administrative proceeding and something which arose during the course of it relating to the presentation and cross-examination of witnesses which you felt should not be caused to comply. I did not think it was a challenge to power.
I was not challenging. The administrative law judge made the absolute correct decision in this case here. He understood the law regarding the rights of cross-examination, And he gave that right to cross-examination. He read the statute properly about confidentiality and decided that confidentiality did not apply regarding complaints made by a witness who has testified in the presence of the accused, and that this was a fundamental right of due process, which was the right to confront your accuser or the complaining witness and ask to see whether, considering charges were 5 to 15 years old here, to see if there was a prior statement that would contradict or shed some light, because you have to understand that in this particular case, what we have here is a one-on-one a psychiatrist who is being accused of sexual abuse with a patient with no other persons present, and the whole issue is credibility that we're dealing with here, the credibility of two people in a room.
Now, wait a minute, now you see, I've lost it again.
Okay, what I'm
sorry,
saying
I
is,
thought I had it for
the
a moment,
administrative
but I
law
lost
judge
it.
made a correct decision, and he said that
But you have, you see, are you challenging the power with respect to the ruling or holding the hearing?
No, I'm challenging the Commissioner of Health, who, without statutory authority, overruled the administrative law judge's ruling made during the hearings. In other words...
Oh, okay, then I'm
here-
not so sure my focus was wrong.
No, the Commissioner of Health went ahead and in effect substituted his legal judgment for the purportedly, or the intended impartial legal judgment of the administrative law judge who was appointed by the legislature to make those rulings. And over the course of...
See, I thought the appellate division's ruling, the appellate division granted leave to this court, related to the fact that you were not given the opportunity for proper discovery.
No, I was given, no, discovery, forget about discovery, we never got discovery. In the course of the hearings, a ruling was made. The administrative law judge ruled against the commissioner and said, produce these documents and let these people answer the questions. The commissioner said, no, we won't answer them. The administrative law judge said, look, I'm going to adjourn these hearings for a month. You either produce these documents and let these witnesses answer the questions, or bring me back a ruling from a court that says that I'm wrong. And the commissioner did neither. He waited the month, and he came back and he says, I am not going to permit my witnesses to answer the question, and I'm not going to produce the documents. You don't have any authority to do that. At that point, the administrative law judge said, well, under the circumstances of denying cross-examination, the panel cannot consider the testimony of these witnesses. And that was the end of the case. They wrote it. Now, the administrative law judge is the one who wrote the report. Under the statute, he's charged with that. And he said to the commissioner, help us. We can't get on the merits. Either go to court and get a ruling that I'm wrong, or tell your department people to produce the documents that I've commanded them to produce and let their witnesses answer. What does the commissioner do? He doesn't do anything. He says, you're overruled, and you go on with these hearings. The man can't have cross-examination on these issues, and nothing in the statute gives the commissioner that power. The only thing the commissioner can do is make a recommendation to the Board of Regents. Curiously, in the case that is being argued with us in Gross v. Ambach, which is the case right behind me, that's exactly what the commissioner did. He made a recommendation to the Board of Regents, which in turn reversed the administrative law judge. There he did not usurp the power. Thus, in answering the question on the exhaustion of administrative remedies issue, the cases in my point 3 at page 49 of my brief are quite clear that where an interlocutory order of the commissioner, such as here, is challenged as wholly beyond his statutory grant of power and is challenged as being unconstitutional, then there is an exception to the exhaustion of administrative remedy rules. That's Village of Herkimer versus Axelrod. It's this court, citing Watergate, and we have several other cases here where this court has ruled that this is entirely appropriate. Yes, sir.
I'd like to ask a question about the role of the administrative officer. In many situations where there's a determination made by an administrative official, let's say, the Commissioner of the Department of Environmental Conservation, where you have a hearing conducted by an ALJ, rulings made, testimonies made, a report made. That report then goes to the commissioner, and ultimately a determination is made. Or you take a situation like a chief of police, disciplinary proceeding. Under a charter of a city, he may have the ultimate authority to impose discipline, but he designates someone to hear and report. But he makes the determination.
But here, the commissioner doesn't make the determination.
Now,
It's the
that's
Board of
what
Regents.
I want to try to understand what the role here
I will
of
tell
the
you, Judge
administrative
Hancock, I
officer
will-
is and how it's different from the two situations that I put to you.
Very unusual statute, Public Health Law 230. Under the education law, the licensing or the revocation of a license or sanctions on the license of physician are entrusted to the Board of Regents. And in fact, in 1975, and a number of occasions, the Commissioner of Health has tried to have the legislature change that so that he would be the ultimate authority to decide whether a physician kept his license. The Board of Regents has that authority. Now, in 230 that we're dealing with, which is within the public health law, it says that the final decision is the Board of Regents. But it sets forth a procedure designed, designed to protect due process rights, and it gives the commissioner certain very precise and limited powers. Now, these limited powers are as follows. With the consent of the governor, he designates members to the Board of Professional Conduct. I believe it's 18 physicians and 7 lay people. His office of professional medical conduct acts as the prosecutor. This is at the time of this we're dealing with it, in conjunction with the Board of Medical Conduct, and they investigate charges, and they prepare as prosecutor, and they present them to the committee. In addition, he appoints an administrative law judge who must be an attorney licensed to practice in the state of New York. That is because until we had that, doctors and lay people had no idea what rulings to make, and it was just filled with error, the procedures in terms of fundamental due
Did the
process.
administrative law judge have the power under the formulation you have to conduct this hearing?
He cannot vote, and he makes all
Can he
rulings.
conduct
Yes.
this hearing?
Not alone. He must, yes, he is a
He can
judge.
conduct this hearing, and then he makes certain rulings.
He rules, he has the authority to rule on all motions, procedures, and other legal objections, and shall draft the conclusions of the hearing committee.
Now, as I understand it, he made a ruling here with which you do not agree.
No, I agreed with it.
I mean, excuse me, that your adversary does not agree.
If I didn't
Fine,
agree
fine,
with
I'm
it,
sorry, of
I wouldn't have a
course, of course.
chance.
All right, that you're, a ruling that your adversary does not agree with.
It's the
And therefore,
commissioner,
the
right.
appellate division held that you were precluded from gaining certain information which you needed.
More so, they said they violated my constitutional rights and the
Right,
statute.
Fine, that's what I was talking about in terms
Right.
of depriving you of discovery.
That's
So that
not
you couldn't-
discovery, it was in the hearing.
All right, I'm trying to use the
Right,
language
okay.
the appellate division used.
Oh,
in
okay,
one-
yeah,
in
you're
one
right,
part.
they did use that word, I'm
That's right.
sorry. You're honest.
Okay, now, so therefore you were deprived by virtue of that ruling. Now, my question to you is,
No, I was deprived, the commissioner reversed. I was deprived of nothing I was given the correct decision. It was stonewalled by the commissioner as prosecutor. And then the commissioner steps in and says, not only am I prosecutor, but now I'm overruling the judge.
now why, you see, and my question is, again, and I realize that my focus might be somewhat distorted, but my question is that when this goes as a normal administrative proceeding before the proper administrative tribunal,
I would have
why
to-
don't we wait until
You're right.
the
If it was
administrative
normal.
hearing is terminated, and then you have the commission review, which is in the arena, and then eventually, if it's challenged because you feel it's unfair, it goes up for Article 78 review.
I agree with that procedure, but that was the
Now, if that's
procedure,
the procedure
but that's
that
not
should
the
be
commissioner. He
if
stepped
that's-
in.
If that's the procedure that should be followed, why should we at this stage, as the court of last resort, be reviewing these determinations in an administrative agency?
It's this, I'll tell you why. in the normal course of events, that's what the commissioner should have done. The commissioner should have followed the rulings of the administrative law judge, because he, according to the statute, has the power to rule on all procedures, motions, and objections from any party or the committee. He should have obeyed the rulings of the administrative law judge, and then, if he objected to that at some later point in the proceeding, he could have...
Mr. Halpern, what I'm saying is you can be entirely right. Everything you say could be true. You might have been deprived 10 ways from center. What I'm saying is, what are you doing here?
Because what we have is a runaway
Now.
commissioner. Yes, we have a runaway commissioner who has gone ahead, stepped in without a scintilla of authority. And I don't care what my adversary says, I challenge this bench to read Section 230, who goes ahead and says, I don't like the rulings of the administrative law judge, even though I'm limited to making recommendations to the Board of Regents, I'm overruling it.
How many times will you be up here before this hearing is concluded?
Not if you do your job and say
My
that...
answer is you should only be here once.
This should be the
and
only
then
time, because
after it is
you have to
concluded.
make the law that the commissioner is bound under 230 to follow the rulings of the administrative law judge, and that his power is limited only to making recommendations
Now
to
you
the
go
Board of
back.
Regents.
Now, let's assume we make that ruling.
Right.
Then we go back, and you go right back before the administrative agency.
And they either produce it or dismiss the charges. That's the
Okay?
ruling.
All right, now they produce, and you proceed with it, and then
That's
let's
correct.
say you lose. Then you can come up here again challenging the ultimate ruling.
Yes, what you're saying is true, but in the reality, what they have done is this. They have tainted the proceedings. You have no idea, I mean, in terms of the expense that's involved and the procedures. You've got a 5-man panel who serves without pay in there, and it's a clearly an unconstitutional ruling here.
Halpern, we have cases that a jury is composed of 17 people, clearly wrong, clearly unconstitutional, or 3 people, clearly wrong, clearly unconstitutional. And you know what we say in those instances? Try the case.
Judge,
You're not entitled to a writ of prohibition.
I
When
don't-
the case is all concluded, come up here, and then we'll reverse. And the reason we do that is because not only of constitutional mandate, but because of a necessity for economy.
this is not, I would say, Your Honor, that if this ruling was made against me by the administrative law judge, you're absolutely right. I would have to go through the entire proceeding and then go ahead and wait for the Board of Regents and take an Article 78. This is where we have an agency which has clearly gone way beyond the bounds of statutory authority and rendered an unconstitutional move and beyond the statute. The cases are clear from your own court, and I believe you've participated in these decisions. If you read starting on page
Within the
49...
last 15 years, you're probably right.
You've been involved in all of these, and now you ask me this? Yeah, I would submit that you have not entirely familiar with the history of this statute, and that there are some of the questions that have been asked by this bench that I have found rather astonishing, where the basic fundamental Judge Hancock, who did not know that the Board of Regents is the ultimate authority here and not the Commissioner of Health. I suggest that homework has to be done here on these
Every
cases.
argument we hear is an educational experience, Mr. Halpern.
Well, Your
We
Honor,
learn a great deal, and we continue.
I'm
We
sorry,
continue, no, we continue to read the briefs and study and try to improve our knowledge of these matters.
If the Board of Regents rules in your favor, you ultimately may never be back with an Article 78.
If that is going to be the ruling on the issue of the interlocutory order of the Commissioner, what you are inviting is a lawless situation where every ruling that the Commissioner does not agree with during the course of the hearings is overruled by him, and you can strip an accused physician of every right he has, whether it's cross-examination, the right to confront or present witnesses, or any type of fundamental due process. You are giving a license to the Commissioner to go ahead and say you have no rights whatsoever, and anything he disagrees with, his prosecutor, who is prosecuting the accused, says to the administrative law judge, we don't agree with your ruling, no matter what it is, and the commissioner's going to back me up because it is the commissioner speaking through his prosecutor, and that's the way it's going to be. And what you're creating is a Kafkaesque proceeding or star chamber where the prosecutor is the judge. Now, that is not the intention of the legislature. It has been gone over and over. The legislature, every few years, has strengthened the statute for due process rights. And what you're saying here is exactly what the commissioner wants, is to grind the accused into these proceedings and make these rulings. You have to bring this to a halt where the commissioner has to be bound by rules of law just like anyone else.
Thank you very much. Mrs. Wickel?
The legislative history, quite to the contrary, is directed towards trying to streamline the process and not permitting these sorts of collateral attacks.
Well, even streamlining process doesn't excuse the lack of due process.
Well, Your Honor, there was no lack of due process here. Cross-examination is permitted to a reasonable extent. If the commissioner had not acted here in this particular situation, the entire purpose of the legislative scheme to encourage people to come forward. You got to remember, this is a sexual abuse case. Think how difficult it is for these 4 women to come to this hearing after years of what they allegedly went through. If the commissioner had not acted to state what the law is, it would not necessarily only have helped this particular hearing, but it would have given a message out in the general public, which is if you go to the OPMC and report professional misconduct and you're later subpoenaed to a hearing, you're going to have to explain to the physician that you complained and what you set forth. And the legislature said to us in these hearings that complaint is confidential. The commissioner had to act in this situation. It is not a question of due process. First of all, due process is premature, but secondly, this physician's counsel has cross-examined these women at length about every single thing in their history, including other complaints. There's this one narrow, limited area where he was told you can't ask because the legislature said we have to permit these people to come forward. The other point I'd like to simply make, besides noting how many of these collateral proceedings come up and how frequently people might be encouraged to challenge not only the commissioner's jurisdiction but the AEO's ruling, is that in this scheme, Judge Hancock, what the legislature basically did is it set forth an administrative officer to assist the committee. The committee makes the findings and conclusions and the recommendations. They're supposed to take account of the rulings made by the officer. The commissioner is given, under the specific terms of the statute, the right to review all of the findings, conclusions, and recommendations, and then make his own recommendation to the regents. There is
Thank you very much.
Thank you, Your Honor.
Rose versus Ambach?
Thanks for the education.
Court, please.
Mrs. Squadron, edify us.
Well, Your Honor, I've listened to this argument, and you will forgive me, I'm going to take off from what Mr. Halperin started. I do want to say to you that I was planning to end my argument by quoting John Adams, who said in 1779, when discussing the Declaration of Rights in the Massachusetts legislature, that the colonists and the founding fathers were writing constitutions and laws to the end, I'm quoting, to the end that it may be a government of laws, not of men. I agree totally with Mr. Halperin that we cannot leave it to the Commissioner of Health of this state to act as investigator, prosecutor, judge, and jury, and that we not only should not do so because of the enormous due process problem that would create in every single matter involving medical misconduct charges, we ought not to do it because it violates basic canons of statutory construction.
Squadron, you understand that some of the questions directed to Mr. Halpern related to our reviewing power in the context of the case at that particular time. That's a difficult problem, one not to be minimized, even though we might discern some mischief in the administrative proceeding, or indeed even in the administrative makeup or hierarchy.
I understand that thoroughly, Your Honor. I would simply like to call the court's attention to that series of cases, which unfortunately I didn't cite in my brief. I thought it was kind of black letter law, and I apologize for it. But that series of cases that starts with Cursix against Merchants Mutual Insurance Company.
Oh, we're familiar with that.
I know that, and
it is black letter law.
It is black letter law, and it's been applied with Mr. Ambach, and it's been applied with Dr. Axelrod in the third department. It's been applied in this court many times. If a statute is clear, the administrative interpretation of it is irrelevant. This statute says, in the clearest possible terms, and I'm referring now to section 230.10e, that the administrative officer does not serve as the delegate of the Commissioner of Health. He does not serve by his pleasure. He serves by the mandate of the legislature of the state of New York. That section reads, the commissioner shall designate, not may. He has no option. Shall designate an administrative officer, admitted to practice as an attorney in the state of New York, who shall have the authority, not may, shall have the authority, to rule on all motions, procedures, and other legal objections. All other legal objections. What is more, the rest of the statutory framework is equally clear. It is not true, as Mr. Zwickel has just said, that the legal officer is there as an advisor to the panel. On the contrary, the legal officer is there to make legal rulings. The panel decides the facts. The legal officer writes up the report. But on legal matters, the administrative officer is not only the last word, but in our case, when we got before the Regents Review Committee, the Regents Review Committee went out of its way to say, and I quote, this is at Joint Appendix 226, while an administrator's office's ruling on a question of law may be dispositive as to a hearing committee, it is not dispositive as to the Commissioner of Health or the Board of Regents, we interpret the statutes as also empowering the Regents, but not the Commissioner of Health, not the Commissioner of Health, to reverse an administrative officer's rulings on questions of law and, if appropriate, to remand the proceedings to the hearing committee. The statutory scheme is absolutely clear. The only power the Commissioner of Health has is to take whatever comes to him from that hearing panel. Mr. Halpern's case, what came was essentially a dismissal of the case. The hearing officer, the administrative officer said, listen, if you're not going to produce that evidence that I asked you to produce, I'm dismissing this. I'm not going to let the panel consider the evidence these witnesses gave. He can then take that and say, I don't agree with this hearing officer's ruling, and kick it up to the Board of Regents. And then the Board of Regents decides. It is the only agency that has the power to decide. There is a serious question about whether the Board of Regents...
Your case is somewhat different.
Yes, I'm about to get...
You challenged initially subject matter jurisdiction.
I'm about to get to my case, Your Honor. I'm simply...
Well, I would suggest that perhaps... Well, all right.
I'm sorry. It is all within the same framework. Because the appellate division...
You think that the procedural posture of the two cases is basically the same?
No. I think our case is a case that is a much more serious one because we were dealing with subject matter jurisdiction. And clearly where subject matter jurisdiction is involved, we did have the right to a writ of prohibition, and I don't think there's any question about it. I think all of the exhaustion of...
So you see the distinction?
I do see a distinction.
I'm not completely out of focus, am I?
Your Honor, I know you are never completely out of focus, and I would certainly not
Sometimes
suggest...
a little out of focus.
I would certainly never suggest you are, not suggest you are in this case. My point is that the appellate division in this case also went off the beam. In this case, the appellate division says that they don't read the Section 230 to preclude the Board of Regents or the Commissioner of Health from reversing legal determinations by the administrative officer. They're wrong, just wrong. And nor are we convinced the legislature intended to remove from the Commissioner of Health and the Board of Regents the ability to make the legal determination whether a given set of facts fell within the scope of the statute. That's wrong. That's dead wrong. You cannot leave it where the statutes are clear to the administrative agency to tell you what's covered and not covered. That's a question of law. It's a question of basic subject matter jurisdiction that has to be determined as a matter of law. Now, what I would like to point out about that in this case first is that the same exhaustion arguments that were made in the previous case are made in this case by the Attorney General. Those exhaustion arguments have nothing to do with this case, although up until page 29 of the Attorney General's brief, that's all he deals with. They have nothing to do with this case because in this case, the subject matter jurisdiction issue was decided by the administrative officer in our favor. It was forwarded to the Commissioner of Health because what happened was the case was dismissed on the ground that subject matter jurisdiction was lacking. The Commissioner of Health then said, I don't agree with the administrative officer, and wrote a recommendation to the Board of Regents. There was then a hearing before the Regents Review Committee, from which I have just quoted. The decision after that hearing I've just quoted from. And there was then a decision by the Board of Regents, and we are appealing that decision by the Board of Regents. In terms of the subject matter jurisdiction issue, there is no exhaustion issue in this case. The Board of Regents, although it remanded the case for a hearing on other questions of procedural irregularity and so on, came to a final decision on subject matter jurisdiction. They decided that, in fact, when you dealt with dead bodies, you were covered by the medical misconduct statute. That forensic pathology was part of the practice of medicine, which we don't deny. And that as a result, the statute, which defines medical misconduct, covered the activities of Dr. Gross as the chief medical examiner of the city of New York. Now, I would like to turn to that issue because that, for us, is the central issue. And it is the central issue for a rather obvious reason. If we are right on subject matter jurisdiction, we prevail. If we are wrong on subject matter jurisdiction, we lose. All of the arguments about exhaustion of remedies and the power of the administrative officer is secondary to that issue in our case. Now, it's perfectly clear that this is a statute, this medical misconduct statute, that's quasi-penal in nature. It's obvious that if somebody loses his profession, his reputation, his livelihood, he is being punished severely. It's obvious also that the process by which this determination is made is quasi-judicial in nature. The whole hearing panel setup, and the appeal to the Board of Regents, and then the appeal to the courts. And therefore, I submit to the court that the statute ought not to be interpreted beyond what it obviously says. And yet that is what has happened here. The administrative officer in this case happened to be the chief law administrative officer of the Department of Health. And she wrote an opinion which you will find at Joint Appendix 56 through 76. I particularly commend to you the portion from Appendix 69 to 76. We consider that opinion to be extremely well-reasoned, extremely thoughtful, reflecting a very careful parsing of all of the relevant statutory provisions. Since this is, as I say, a quasi-penal statute, any contrary interpretation has to be more than superficial. If somebody is going to take this law officer's ruling and turn it on its head, one has got to do more than say, diagnosis means determining the cause of death or deciding the manner of death. Diagnosing the cause of death is the most tortured use of the word diagnosis that I have ever heard. And yet it is on that kind of torturing of a single word that the administrator's office's ruling was overruled, first by the Regents and then sustained by the appellate division. It's purely the word diagnosis. Now, the word diagnosis appears in the course of a series of words talking about operating, treating, and so on. Clearly applying to live patients. There's not the slightest doubt about it. The fact of the matter is that we cite the veterinary medicine definition, where they apply there the same words, diagnose, operate, treat, so on. And they then define who it applies to. And the veterinary medicine section applies to every living creature except a human being. But we know that if a horse dies after a race, and they are worried about whether it's been drugged, They will have an autopsy of that horse. Are they diagnosing the cause of death? They're determining it. They're doing what forensic pathologists do. The person who does it is a veterinarian. He's a licensed doctor of medicine for animals. And the forensic pathologist is a licensed physician. In this case, the chief medical examiner of New York. It's difficult to consider that when the forensic pathologist is practicing his profession, he should not somehow be covered by these medical misconduct statutes. But the fact is they aren't covered. Now, I'm not saying the legislature could not cover them. They could. But the legislature determined, because they were concerned about medical malpractice charges going up, to deal with medical misconduct with people who sue for malpractice. Whatever you do with dead bodies doesn't apply here. I respectfully request that this court take a look at the charges against Dr. Gross, quite apart from the fact that all of these charges were considered false and unfounded, I quote, by a commission of 12 lawyers headed by Arthur Lyman, all of them previously prosecutors, and all of them starting out with this New York Times barrage against Dr. Gross that they had to give some credibility to, you know, where there's smoke. And 5 pathologists, specialists in the field that Dr. Gross is in. They found all the charges false and unfounded. I respectfully request that you look at the charges. Of the cases that the health department decided to pursue Dr. Gross with, of them, 3, he was not even the one who performed the autopsy. 4, of which 2 were part of the 3, were never presented to the investigating committee. 1 related to expert testimony he gave in a case in New Jersey. The health commissioner decided he didn't like his testimony, he liked the testimony of the other expert. And on that basis, the pursuit ran on, clearly instigated by the New York Times series, and clearly inappropriate and improper. And when the administrative officer found there was no subject matter jurisdiction by parsing the statute, instead of saying, enough already, they went ahead and they reversed after the argument before the Regents Review Committee. I ask this court not only to read the charges, but no matter what decision you make, give a message to the Department of Health of this state. Give a message that the Commissioner of Health may not be the investigator, the prosecutor, the judge, and the jury. Give a message as to what it is that they have to do in order to comply with the statute. Tell them, are you permitted to go after a chief medical examiner on the basis of supervision of administrative activity? Are you able to do it regardless of whether or not the charges have been presented to the investigative committee of this panel of the Board of Professional Medical Conduct? Regardless? Just take them because some person who is a staff person decides she wants or he wants to present the charges. In this case, I say she because it's a woman named Kathleen Tanner who did it.
Thank you very much, Mrs. Marshall.
I'm sorry.
Mrs. Wickel? Mrs. Wickel, this is quite a different procedural posture, would you agree?
Yes, I would, but in terms of our position on exhaustion, I don't think the ruling from this court should be any different.
Except that here we have an initial challenge of subject matter jurisdiction, which would seem to sound like something that relates to a prohibition.
Well, Your Honor, it certainly does sound like it, but I think the answer on that question is twofold. One is whether or not one characterizes this as subject matter jurisdiction, or rather what might properly be said as a failure to state a claim under the statute. What the Regents did here was to remand the matter back to the committee, where the issue, once again, will be preserved for review. I'd like to also point out that the remand, in fact, took place. Hearings occurred on the procedural issue, and the petitioner in this case has gone to court again, challenging that determination. I think on the exhaustion claim itself, we feel that to the extent the issue does not implicate, again, the legality of the entire proceedings, and to the extent there's an adequate remedy after the hearing is concluded, that the ruling from this court should be no different than the ruling in Doe. If I can address the authority of the administrative officer again very briefly, I'd like to make
We
a
could
couple
very
of
well
points.
find, couldn't we, that the State Board of Professional Medical Conduct does not have subject matter jurisdiction?
You could, if you were to reach the merits of the issue, and that would, in fact, end the proceedings. However, once again, I think what needs to be counterbalanced on that issue is the fact that the issue will be preserved. There's an adequate remedy. One may say that it's not even subject matter jurisdiction, that it's a question of the reasonableness of the Regents' interpretation of the statute. And I think if you look at this court's prior decisions on what one might call reasonableness of interpretation, this court has held that that is really a premature issue for judicial review. I think this is a more difficult
Subject
case.
matter jurisdiction is premature?
Well, I'm sorry, I'm not calling it subject matter jurisdiction. I think that if, in fact, the issue was the competence of the state to go after Dr. Gross, that would be a more difficult question. But I don't think it's really a question of competence. I think what's really involved here is a question of how you interpret the definition of practice of medicine. And we feel that that issue is not so
Again,
clear.
of course, the issue of competence doesn't necessarily relate to the overriding effect of whether it has the power.
That's correct. On the authority of the administrative officer, I think it's a very difficult thing to believe that the legislature, in constructing the scheme of an administrative officer who makes initial rulings, intended that that administrative officer would have the final authority to decide what is the scope and meaning of the practice of medicine in the education law. Not only is that an unreasonable position, we feel, but it certainly is not supported by the language of the statute, which never uses the word final. Neither is it supported by the legislative history. I'd like to also note that this case is different than Doe in two respects, of course. One is that the administrative officer here made a, quote, final determination and dismissed the charges. Secondly, to the extent there was, which the reason why that's relevant, of course, is that final determinations are supposed to go through the administrative process. That's what the legislature set up in 230 of the public health law. But secondly, to the extent there's a concern with the role of the Commissioner of Health acting in various capacities, which we don't think is a legitimate concern, but to the extent that was at least an issue in Doe, it's hardly an issue when you're dealing with the Board of Regents, which is a separate body which doesn't designate the administrative officer. And one could hardly imagine that the legislature intended that the Board of Regents not be able to consider a ruling on the scope of the education law. On the merits of the claim, if this court were to reach the question of the definition of the practice of medicine, I think initially we have to begin again with the statutory language. And the language in the statute, which says diagnosis for any disease or condition, does not use a term living patients. It in fact doesn't use the term patients at all. And one can hardly believe that when Dr. Gross performs his medical duties as medical examiner, and he's a physician licensed in the state, that Dr. Gross is not practicing medicine within the meaning of the education law. To reach that conclusion, I would state that we need a clear direction from the legislature, which is not in the statute.
Some people who are not doctors can perform autopsies, so can they not?
That's not correct, Your Honor.
I beg your
That's
pardon?
not correct. the coroner's provisions in the county law, which we addressed at length, make it clear that...
I thought anatomy professors could perform autopsy.
Oh, I'm sorry. That's not correct either. If I can relate to that, what the legislature said in the public health law, 4209, is that anatomy instructors could be involved with the incisions as part of their teaching research responsibility. But an autopsy is considered a very different procedure. It's a determination, it's a medical, legal determination of the cause of death.
What would I rely upon to draw that distinction? Is there some statute that would make that distinction?
There are a number of statutes. The county law, which deals with the responsibilities of coroner's physicians and medical examiners, specifically sets forth that only a physician can do an autopsy. That provision, the provision in the public health law, was certainly intended to identify the type of persons who could make incisions in dead bodies. And certainly you're correct, it does mention anatomy instructors. But it was not the intent of the legislature, I don't believe.
Well, where is it written? That's what I'm trying to get from you. Where is it written that only a licensed physician may perform an autopsy?
I believe the clearest statement of that effect, there are two things. One is, I think in the county law, where they deal in section 671 and 673 of the county law, where they deal with performing autopsies. If you look at 673-2,
Is it in your brief?
yes, it is, Your Honor.
Can you give me a page?
And it's on page 51 of our brief.
But 4209 of the public health law, it talks in terms, you're quite right, of incision, but it talks in terms of preparatory to or during an autopsy.
I believe that when the legislature enacted that statute, two things were going on. One is, I think that the legislature clearly intended that the actual performance of autopsies themselves be done by physicians. That provision, in large part, deals with doctors and physicians and dentists and medical personnel.
Instructors of anatomy, as
To the
Judge
extent
Simons points out.
it does, but to the extent it talks about instructors of anatomy, I think the reasonable interpretation of that, taking into account other provisions of the education law, which it talks about the practice of medicine, and the county law, which it talks about coroner's physicians and medical examiners performing autopsies, is that the autopsy, which is defined in medical dictionaries, is really a very separate thing than an anatomy instructor in a research laboratory with students giving instructions in dissecting a cadaver. I don't think...
Except, you see, the word autopsy is used in that section.
You're right, Your Honor.
And we can't assume the legislature didn't know what it was talking about.
Well, I think to the extent the legislature said anatomy
And
instructors...
you and I have both read Cursius. Cursix. Can't pronounce it, but we've read it.
But even if that were true, and even if you were correct, I don't think that necessarily would go back to the fundamental question here as to whether or not a forensic pathologist, when he's performing his autopsies, which involves, as Education Law 6521 says, diagnosing any human disease, that pathologist is not practicing medicine. That by itself is an unreasonable interpretation. I'd also like to point out that the petitioner in this case raises an issue about the use of the word diagnosis and tries to suggest that that's really a term of art, that it's different than determine and ascertain and other provisions. Well, that's not really supported by either the medical literature, which defines diagnosis in terms of determination, or a provision which, I'm sorry, is not cited in our brief, which is County Law 677, Subdivision 2, which deals with coroner's reports on autopsies and uses the term, in terms of the report of the means or manner of death, it says that the coroner's physician shall append thereto the diagnosis of the cause of death and the means and manner of death. and I think it's clear in that section of the statute, which is County Law 677-2, that the legislature used the word diagnosis interchangeably with the other words that it's used in the education law. In addition, as the appellate division found, if the legislature wants to specifically say living patients, it knows how to do it. It did it with respect to veterinary practice. It did not do it with respect to the practice of medicine. The administrative officer, in her ruling, believed that the legislature only intended to protect the public, and therefore it was unreasonable to interpret the practice of medicine with respect to dead persons, not live persons. Well, as we've argued, there's no support for that in the statute, but also we all know that when medical examiners perform autopsies and get the results of autopsies, that whole practice of forensic pathology has many, many results for the public. It's been used to help in Legionnaire's disease. It's been used for statistics. In fact, one may say, as a number of the experts who were included in the record said, that the work of the medical examiner and the work of the pathologist has a great deal to do with the public at large and with our dealing with disease and fighting disease. To think that the legislature in this statute intended to take a specialty of medicine, forensic pathology, and exclude that from any oversight by the state medical board, I think is not only unreasonable, but it's not consistent with a sound public policy. Our argument essentially is that the terms of the statute do not support the petitioner's argument, that the regents interpreted the education law, due deference should be given to the judgment of the professionals in this case. The Commissioner of Health, who recommended a similar determination, is a physician and relied on sound medical practice and knowledge as well as an application of the statute, and that determination should be upheld by this court.
Thank you very much, Mr. Wickham. Datiz versus Shoob.
Ready.